Judiciary. द सुप्रीम कोर्ट, द अमेरिकन कॉन्स्टिट्यूशन में सेपरेटेड जुडिशरी होती है, सेंट्रल लॉज होता है सेंट्रल जुडिशरी, स्टेट लॉज में स्टेट जुडिशरी। इंडियन कॉन्स्टिट्यूशन में इंटीग्रेटेड जुडिशरी, यूनिफाइड द जुडिशरी, ब्रॉड द गवर्नमेंट ऑफ द इंडिया एक्ट 1935 द इन्फोर्स द स्टेट एज वेल एज द सेंट्रल लॉ। द सुप्रीम कोर्ट ऑफ इंडिया में क्या होता है, इन inaugurated 28th January 1950, repealed the Federal Court of the India established by the Government of India Act 1935 में बना था। अर्लियर अपील फॉर द फेडरल कोर्ट ऑफ इंडिया सो ब्रिटिश प्राइवेसी काउंसिल में होता था। नाउ द सुप्रीम कोर्ट ऑफ द इंडिया हाईएस्ट कोर्ट ऑफ द अपील इन द कंट्री। द जुरिडिक्शन में द सुप्रीम कोर्ट ऑफ द इंडिया ग्रेटेस्ट एंड देन द फेडरल कोर्ट ऑफ द इंडिया। द सुप्रीम कोर्ट में द पार्ट 5 में होता है इंडियन कॉन्स्टिट्यूशन, आर्टिकल 124, आर्टिकल 147। द हाई कोर्ट होता है हाई कोर्ट इन इंडिया ऑपरेटेड द बिलो द सुप्रीम कोर्ट ऑफ इंडिया। द एबव द सबऑर्डिनेट कोर्ट होता है हाई कोर्ट में, टॉप जुडिशियल कोर्ट विद इन द स्टेट में होती है। The origin of the High Court created in the 1862 by the Indian High Court Act 1861। कलकत्ता, बॉम्बे एंड मद्रास में बना था। 1866 में इलाहाबाद हाई कोर्ट बना था। हाई कोर्ट सुनना पार्ट 6 में आते हैं इंडियन कॉन्स्टिट्यूशन। आर्टिकल 214 से लेकर आर्टिकल 231 तक आता है। करेंटली द 25 हाई कोर्ट इन इंडिया। आर्टिकल 214 में हाई कोर्ट फॉर ईच स्टेट। आर्टिकल 231 क्या बोलते हैं, रिप्लेस्ड बाय द 7th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट 1957। द पार्लियामेंट बाय द लॉ एस्टैब्लिश्ड बाय द कॉमन हाई कोर्ट 2 more states or 2 more state and the union territories। Jurisdiction of a high court same as a territory as a state। Jurisdiction of the common high court the same as a territory of the states and union territories that come under the jurisdiction of the high court। Article 220, the parliamentary by the laws they extended or they reduce the jurisdiction of the high court, included or excluded union territory, the composition and the supreme court, the current strength of the supreme court, 24th chief justice of India and the 33 जजेस एंड द ओरिजिनली स्ट्रेंथ द 1950 में क्या था, 8 था। 1 चीफ जस्टिस एंड 7 जजेस एट द आर्टिकल 124 में पार्लियामेंट बाय द लॉज। द इंक्रीज द नंबर ऑफ द जजेस सुप्रीम कोर्ट नंबर ऑफ द जजेस अमेंड एक्ट 2019 द 24th स्ट्रेंथ अमेंडमेंट द सुप्रीम कोर्ट नंबर ऑफ द जजेस एक्ट 1956। The appointment of the Supreme Court, a President of India appointment as a Supreme Court judge, Article 124, the consultation and the Chief Justice and the judges of the Supreme Court and the High Court as a thing fit, the consultation with the Chief Justice and mandatory। Chief Justice में क्या होता है, appointment by the President, Article 124, consultation the judges of the Supreme Court and the High Court as a think fit, the consultation with the Supreme Court consultation में mentioned in the constitution the exact meaning of not the defined, the interaction of the Supreme Court, the first judges code 1981 में आया था। Consultation तो does not mean the concern, the exchange of the view। second judge case 1993, the preserve the first judge's case। Consultation means the concern, advice of the Chief Justice of India binding on the President of India, matter of appointment of the judges of the Supreme Court and Chief Justice given to advice after the consultation to more senior most judges of the Supreme Court। Second judges case 1993 में senior most judges of the Supreme Court to be the appointment Chief Justice of India, not the other junior judges। Third judge case 1998 में आया था consultation with the Chief Justice of India, consultation with the plurality of the judges, the sole opinion of the Chief Justice of India, not the consultation। Chief Justice of India consults the collegium for senior most judges of the Supreme Court if 2 judges advisor opinion। टू जजेस एडवाइसर ओपिनियन होते हैं। and the name of the judges not be the recommended. Recommendation में क्या होता है, made by the Chief Justice of India without the consultation, not binding on the President. The North Judges Case 19 to 2015, the Supreme Court declared the null and void the 99th Constitutional Amendment Act 2014, the National Judicial Appointment Commission Act 2014. They inserted the Article 124A, the National Judicial Appointment Commission. The inserted Article 124B, the function of the Commission, and inserted Article 124C, the power of the Parliament to make law to regulate the appointment of the judges, against the independence of the judiciary, against the 24th rules of the laws. The composition of the High Court, Article 216 60. The High Court may consist of the Chief Justice of the High Court, other judges number decided by the President, and depending upon the workload, advice of the Union Council of Ministers, view on the concern of the High Court states and may the taken into consideration. The Constitution may have no specific essence of the High Court mentioned. Appointment of the High Court, judges of the High Court appointment by the President of India, Article 217. The consultation Chief Justice of India, Governor of the concerned state, and the Chief Justice of the concerned High Court. The Chief Justice of the High Court appointment by the President of India. The consultation of the Chief Justice of the India is a governor of the concerned state, the common High Court, governor of the state, and consulted the consultation of the High Court. Second Judge Case 1993, the consultation with the Chief Justice of India concerned the opinion and the Chief Justice of India binding. The third Judge's Case 1998, Chief Justice of India consulted two senior most judges at the Supreme Court of the India, the sole opinion of the Chief Justice of India, not the consultation. No appointment to be the made if the Chief Justice has not been consulted with the other judges. Fourth Judges Case 1915. The Supreme Court declared the null and void the 99th Constitutional Amendment Act 2014, the National Judicial Appointment Commission, the Act 19 and 2014. The amendment Article 1 to 17, against the independence of the judiciary, against the 14th rule of the law, qualification of Supreme Court, Article 124, the citizen of India, one of the three conditions to be the fulfilled. The judges of the High Court or the High Court's succession for 5 years. The advocate of the High Court, the High Court succession 10 years. Distinguish jurisdicts of the opinion of the President. No minimum age limit, qualification of the High Court, Article 217. Citizen of India, one of the two conditions to be fulfilled. The held the judicial office, Treaty of India 7 and 10 years. The advocates of the High Court, High Court of the High Court's succession 10 years. The no minimum age limit, the no distinguished jurisdiction to be the appointment by the High Court of the judges. Both Supreme Court, Article 124. The person appointment to be the judges of the Supreme Court. The administer the president or the same as the person appointment by the him to be at the behalf. The components of the oath bear the true faith, allegiance, and the Constitution of India, unsold the sovereignty and integrity of India, ideally and the faithfully, and the best of the ability, knowledge of the judgment of perform the duties of the office without the fear, and the affection of the ill and will, the uphold the Constitution and the laws. The oath of the High Court, Article 219. The person appointment as a judge of the High Court administered by the governor and same other person appointment by him as a behalf. The components of the oath are the bear true faith and allegiance, a Constitution of India, uphold the sovereignty and integrity of India daily and the faithfully, and the best of the ability, knowledge, and the judgment of the perform the duties of the office without the fear and favor of the affection of aliens, uphold the constitution and the laws. Salary and allowance of the Supreme Court. Article 125. Salary and pension allowance and the privileges, leaves and the absence determined by the parliament by the law. The can't be the reduced once a judges and the enters upon the office. Can be the reduced only in during the financial emergency until the a new law passed by the parliament. Salary allowance mentioned in the second schedule. Salary allowance of the High Court. Article 221. Salary and pension opens and the privileges and leaves and the absences that determined by the parliament by the law can't be the reduced once a judges enters upon the office. Can be the reduced only during the financial emergency until the law passed the parliament. Salary allowance mentioned in the second schedule. Tenure of the Supreme Court. Article 124. There are no fixed tenure in the term of the number of the year. Three condition होते हैं: hold the office till 65 years of the age of the Supreme Court, as a Supreme Court judge to be the determined by the any authority in the manner of the determined by the parliamentary by the law, resign the President of India, removed by the President and the recommendation of the Parliament. Tenure of the High Court. Article 217. नो फिक्स टेन्योर इन द टर्म ऑफ द नंबर ऑफ द ईयर्स. फोर कंडीशन होता है: पहला, the hold the office of the 62 years of the years earlier 60 years the change the 15th constitutional amendment act 1963 में हुआ. and the age of the high court judges में to be the determined the parliament of India, consultation chief justice of India, the decision of the president is final होता है. Resigned the President of India, removed by the President, recommendation of the Parliament, vacates the office, the appointment as the judges of the Supreme Court, transferred to another High Court. The removal of the Supreme Court and the High Court. Uh, Article 124. The process of the removal of the Supreme Court judges. Article 217. The High Court judges to be removed in the same manner as the Supreme Court judges. The judges of the Supreme Court and the High Court are removed by the President of India, recommendation of the Parliament. Both the houses of the Parliament passes the address in the same case. The majority of the total membership of the House and the majority of not less than two-thirds of the members present and voting. The President of the Parliament in the same session. The grounds for removal. Proven misbehavior, incapacity. The Article 218. Application of a provision of the Supreme Court and the High Court. Process of the removal of the Supreme Court. Supreme Court judges available to the High Court judges without any changes. The Judges Inquiry Act 1968 regulates the process removal of the Supreme Court and High Court judges, and the removal motion can be introduced in the Lok Sabha or Rajya Sabha. Lok Sabha signed the 100 members given to the Speaker. Chairman of the signed the 50 members given to the chairperson. Speaker of the chairman admit or the dismiss discretion in the admitted. The speaker of the chairman, three member of committee investigate to the change. Three member होते हैं: चीफ जस्टिस ऑफ द जजेज ऑफ द सुप्रीम कोर्ट, चीफ जस्टिस ऑफ द हाई कोर्ट, डिस्टिंग्विशिंग ज्यूरिस्ट. कमिटी बनती है द फाइंड द जजेस गिल्टी एंड प्रूवन द मिसबिहेवियर ऑन इनकैपेसिटी. हाउस कंसिडर द मोशन ऑफ द रिमूवल. The motion passed by the both houses in the some session and the presented to the president in the same session. The transfer of the High Court judges. Article Article 222, the President transferred the High Court judges one High Court to the another. The consultation Chief Justice of India से करेंगे. After transfer, the High Court judges salary compensatory allowance are determined by the Parliament by the law. Supreme Court में क्या होता है? Transfer of the High Court judges only the exceptional circumstances in the public interest. No punishment, not as a punishment measure. Not as a punishment as a measure. Supreme Court judges में judicial review होते हैं to the check the arbitrary transfer affected by the judges challenge of the direction. Third, judges case 1998, the Chief Justice of India consult the collegium. Four senior most judges of the Supreme Court, Chief Justice and two High Courts, and the sole opinion of the Chief Justice of India, not consultation. The acting Chief Justice and the Supreme Court. Article 126, the President to power the appoint the acting Chief Justice. The judges of the Supreme Court appointment as a acting Chief Justice. Chief Justice of India vacate. Chief Justice of India absent. Chief Justice of India the unable to perform the duties. Acting Chief Justice of the High Court, Article 223, the President, the power of the appointment, the acting Chief Justice, the judges of the High Court, and appointment as a acting Chief Justice, the Chief Justice of the High Court, and vacate. Chief Justice of the High Court and absent. Chief Justice of High Court unable to the perform duties. The ad hoc judges of the Supreme Court, Article 127, the when the ad hoc judges appointment, the lack of the quorum of the permanent judges to conduct the sitting and the Supreme Court. Chief Justice of India appointment the judges of the High Court and ad hoc judges. The temporary the period till the time to the necessary condition. The previous consent of the Supreme Court consult the Chief Justice and consult the High Court. The ad hoc judges qualified to be the appointment as a Supreme Court judges priority the setting of the Supreme Court over the other duties. All power and function the privileges jurisdiction of the Supreme Court judges additional and the acting judges of the High Court. Article 224, additional judges, the President appointment as additional judges are eligible for the appointment of the High Court a temporary period not more than the 2 years. Temporary increase the businesses High Court and the aware of the knowledge. Additional judges may less than the 22 years of the age. Article 224, the acting judges appointment by the President qualified to be the appointment as the High Court judges. The judges unable to perform duties, absence or any other reason. A judge appointment as the act of the Chief Justice of the High Court. Acting judges the hold the office. The permanent judges of the comes back. Acting judges less than 22 years. 62 years age of year of the age. Retired judges the Supreme Court, Article 128, Chief Justice of India request retired to the judges of the Supreme Court, retired the Supreme Court judges of the High Court eligible for appointment as a Supreme Court. The act judges of the Supreme Court temporary period होता है Chief Justice of India. The previous consent President of India consent of the retired judges allowance में determined by the President of India jurisdiction powers and privileges. Supreme Court judges may not to be the amend not to dim the Supreme Court of the judges of otherwise the retired judges High Court में Article 224A inserted by the 15th Constitutional Amendment Act 1962 63, the Chief Justice of the High Court of a state request to the retired judges of the High Court to be the High Court or any other High Court act as a High Court judge. टेम्पोररी पीरियड के लिए एक्ट करेंगे. कंसेंट रिक्वायर्ड द प्रेसिडेंट ऑफ इंडिया रिटायर्ड जजेस एक्टिंग एज अ जज अलाउंस डिटरमाइंड बाय द प्रेसिडेंट जुरिडिक्शन पावर प्रिविलेजेस एंड जजेस ऑफ द हाई कोर्ट नॉन नॉट डीम्ड टू बी एज जजेस ऑफ द हाई कोर्ट. सीट सुप्रीम कोर्ट के लिए आर्टिकल 130 दिल्ली में सीट ऑफ द सुप्रीम कोर्ट चीफ जस्टिस ऑफ इंडिया. appoint any other place seat of the Supreme Court approval for the President, the optional provision not binding on the Chief Justice of India. Independent Supreme Court, the highest court of the appeal, the guardian of the fundamental rights and guardian of the Constitution, justice without fear, ill and will, and the freedom of the Supreme Court in encroachments and the pressures and the interference. The Independence High Court, the High Court within the state, justice without fear and ill will, the freedom of the High Court, encroachments and the pressures and the interference, independence, Supreme Court and the High Court. Pala, mode of the appointment, the Supreme Court and the High Court. The judges appointed by the President, consultation member of the High Court, a member of the judiciary, reduce the discretion executive and legislature. Second, and security of the tenure. The Supreme Court and the High Court judges can be the removed President of India recommendation of the Parliament and the proven misbehavior and the incapacity. No pleasure of the President involved. Three fixed services conditions, salary allowance, leaves and pension privileges. Supreme Court and the High Court judges and decided by the Parliament by the law can't be the reduced during the tenure of the judges. For charge expenditure. The Supreme Court salary allowance and pension, judges of staff administrative expenses, charges upon the Consolidated Fund of India. High Court में salary allowance, judges salary allowance, pension staff, administrative expenses, Consolidated Fund of State, pension of the High Court judges, charge upon the Consolidated Fund of India. The five decisions conducted by the judges, the Supreme Court of the High Court, Article 2, 121, the Parliament by the no discussion conducted on the Supreme Court and High Court judges except during their removal process. Article 211, the state legislature no discussion conduct the Supreme Court and the High Court judges. Just 6, ban on the practice of the practice after retirement. Article 2, 124, retired judges of the Supreme Court can't be appealed or the practice before any court of authority of India. Article 220, the retired permanent judge High Court, the appeal for the act in any court. Exception, Supreme Court, other High Court where they have not been held office. 7. Punish for the contempt. Article 129, the Supreme Court the power to punish the contempt. No one can be disobey the court, disrupt the presiding, consult the court. Article 215, the High Court power to punish the contempt. The 8. Freedom to appoint a staff. Article 146, the Chief Justice of the India, freedom to appoint the officer and the servant. Chief Justice may appoint as in any Supreme Court judges or any such appointments. Condition condition of the services and the rule to be the prescribed by the Chief Justice of the India or any other judges appointment by him to that they behalf. Rule related to the salary allowance, leaves, pension, approval of the President. Article 229, the Chief Justice of the Court, the freedom to the appoint the office of the servants and the Chief Justice of any appointment of the any other High Court or for each such appointment. The condition for the services and the rule to be the described Chief Justice or any other judges appointment by him to the behalf. Rules related to the salary, pension, allowance, leaves and the approval of the governor. The now jurisdiction. The Parliament to not authorize the any curtail jurisdiction of the Supreme Court of the High Court. The Parliament to can extend the jurisdiction and the and power jurisdiction and power of the Supreme Court. Uh, Haladi Krishna Swamy Iyer and the member of the drafting committee, the Supreme Court of India. Power and more power to any other Supreme Court, any part of the world. Article 135, the jurisdiction and power and of freedom. The no to be the exercised by the Supreme Court. The allows the Supreme Court to be the decided case and access to the law existed behalf before the constitution. Jurisdiction and the power and the high court. The high court means the highest court in the state. The power to the safeguard the fundamental rights and power to interrupt the constitution. Power of the high court similar to the high court before the recommendation of the constitution. One, the extra power, the jurisdiction over the revenue matters, the exclusive or the original jurisdiction. The exclusive jurisdiction only the specific court, the power to be the where the decided a matter on the other court. The original jurisdiction, the jurisdiction of the court here by the matter in the first instance. नॉट अ वे ऑफ द अपील. ओरिजिनल jurisdiction ऑफ द सुप्रीम कोर्ट में क्या होता है? डिस्प्यूट बिटवीन द सेंटर एंड स्टेट एंड टू बी द मोर स्टेट. आर्टिकल 131 एक्सक्लूसिव ओरिजिनल jurisdiction होती है. The original exclusive jurisdiction of the Supreme Court on the case of matter existence right depends on the matter of the matters and questions, and no question on the political nature and the referred, and case of the private citizen against the center and state not under the original jurisdiction, the allowing the matters not under the original jurisdiction of the Supreme Court. Dispute treaty, agreement, current and engagement, and other instrument enacted the excluded before the commencement of the constitution, not excluded under the commencement of the constitution on its agreement mention original jurisdiction on the Supreme Court will not be applied. The original jurisdiction में Supreme Court not applicable. Interchange river water dispute interested in Interstate River Water Dispute Act 1956 matter referred to the Finance Commission. Adjustment of the certain expenses, pension duties and center and state. The original jurisdiction of the High Court. Power of the High Court Article 225. Here the matter of the first instance and not to be the way of appeal. Matters covered under the election dispute, member of the parliament and state legislature. A revenue matter में relating to the revenue collection, fundamental rights of citizen, case on the transferred from the subordinate court to high court, the interpretation of the constitution. Delhi, Madras, Bombay, Calcutta. Original jurisdiction civil case. High court economic value. No original criminal jurisdiction. Writs and the jurisdiction of the Supreme Court. Article 32. Power of the Supreme Court to issue writs, the enforcement of the fundamental rights. Original jurisdiction में violation of the fundamental rights directly Supreme Court, not to the exclusive aggrieved person, can be the High Court also. The Article 139. Parliament by the laws the confer the Supreme Court the power to the issue writs in the matters of the other than the case of the violation of the fundamental rights. Other judiciary jurisdiction of the Supreme Court. Federal dispute and case of the fundamental rights. The original exclusive fundamental dispute में case of the fundamental rights में original but not the exclusive concurrent concurrent with the High Court. The jurisdiction federal dispute में parties units and federation. Case of the fundamental rights of parties citizen or state. Adds jurisdiction of the High Court. Article 226 Indian Constitution. Power to the High Court issue writs. The enforcement of the fundamental rights and other purposes के लिए कर सकता है. Other purposes में legal constitutional rights. High Court power to the issue writs. Person, government and authority तीनों को कर सकता है. Even the outside the terrestrial jurisdiction, if no violation of the rights took place in within the terrestrial jurisdiction. Chandra Kumar versus Union of India 1997 reads jurisdiction of the Supreme Court and the High Court, parts of the basic structure. And the reads jurisdiction, the Supreme Court versus the High Court. The High Courts सुप्रीम कोर्ट में आर्टिकल 32, द ओरिजिनल बट नॉट एक्सक्लूसिव, द concurrent with the high court only in the fundamental rights, narrow than the high court, narrower than the high court. हाई कोर्ट में क्या होता है, रिट्स रिलेटेड आर्टिकल 226 ओरिजिनल बट नॉट एक्सक्लूसिव होती है, कंकरेंट विथ द सुप्रीम कोर्ट होता है, इन फंडामेंटल एंड लीगल एंड द कॉन्स्टिट्यूशनल राइट होती है, वाइडर देन द सुप्रीम कोर्ट. अपीलेट ज्यूरिडिक्शन सुप्रीम कोर्ट में होती है. द सुप्रीम कोर्ट द हाईएस्ट कोर्ट ऑफ द अपील, द हियर द अपील एंड अगेंस्ट द जजमेंट ऑफ द कोर्ट. द फोर टाइप्स ऑफ द अपीलेट ज्यूरिडिक्शन होता है. पहला कंस्टिट्यूशनल मैटर होता है, दूसरा सिविल मैटर होता है, तीसरा क्रिमिनल मैटर होता है, चौथा अपील्स बाय द स्पेशल लीव्स होता है. कॉन्स्टिट्यूशनल मैटर में द आर्टिकल 132 होती है, अपील फॉर द हाई कोर्ट to the Supreme Court, a certificate issued by the High Court and substantial question interpretation of the Constitution. Any party of the any case issuing the certificate appeal for the Supreme Court. Certificate issued by the High Court. The Article 134A inserted by the 44th Constitutional Amendment Act 1978. Civil matter Article 133. The appeal for the High Court to the Supreme Court civil matter होता है. Certificate of the High Court Article 134A. Substantial question of the laws or general importance involved. The question should be decided by the Supreme Court. Any party of any party of the case approach the Supreme Court with the certificate of the High Court. And no monetary limits in the case which can be appealed in the Supreme Court. One judge judgment of the high, the no appeal directly to the Supreme Court. The Parliament by the law makes such provision. Appeal for the Supreme Court, one judge judgment. The criminal matters Article 134. The appeal for the Supreme Court criminal cases होता है. हाई कोर्ट में sentenced a person death, no certificate required. A certificate case should be decided by the Supreme Court. Condition for the such appeal determined by the Supreme Court or High Court. If High Court the accused or a person the strong and the compelling the reason appeal for the same in the Supreme Court and the state to the matter Pradesh versus the Ram Sajivan 2010. The Supreme Court the same authority in the case of the acquittal and the death sentence. Article 134. Parliament by the law the more power to the Supreme Court in the case of appeal criminal matter. 1970 में पार्लियामेंट enlarged the appellate jurisdiction of the Supreme Court criminal matter में. High Court the imprisonment of the life and for 10 years can be the appeal in the Supreme Court. A special leaves petition Article 136. The Indian Constitution Supreme Court discretionary power. The grant leave appeal from the any judgment in the any matter. The passed by the court or tribunal territory of India. A special leave petition not applicable. And the court of the martial military tribunal. The special leaves and petition not a right to the applicant. A discretionary power and a power Supreme Court के पास है. Against the final earned interim order of the judgment, any matter civil, constitutional and criminal taxation, labor, revenue and advocates etc. Plenary powers. Plenary power the Supreme Court full the complete powers and no limitation or the restriction. The Supreme Court special leaves and petition not be the exercise with the and the causation and extraordinarily situation, no fixed the formula or rule. Especially petition, the corrective jurisdiction of the Supreme Court can't be the change by the law. Judiciary jurisdiction of the Supreme Court the eradicate the justice. The appellate jurisdiction of the High Court. The High Court appeals for the subordinate court junctioning the terrestrial jurisdiction of the High Court civil and criminal matter. Appellate jurisdiction High Court में wider than the original jurisdiction होता है. Civil matter में first appeal appear in the district court, second additional district court, other subordinate court appeal to the High Court question of the law and fact that amount of the above the certain limits. Second appeal to the High Court only one question of law. Some High Court intra courts appeal decision of the single judge and of the High Court appealed by the division bench of the High Court, appeal for the administrative tribunal, appeal division bench and the state High Court. The Supreme Court 1977 decision of the tribunal first challenge in the High Court, then the Supreme Court, then not directly to the Supreme Court. The criminal matters appeals from the Session High Court and Additional Session Court and the High Court. The imprisonment more than the 7 years, death sentence session of the Additional Session Court the can't be the execute without the approval of the High Court. Advisory jurisdiction of the Supreme Court. Article 143 Indian Constitution, also known as the consultative jurisdiction. The President authorized and seek to opinion and Supreme Court and two categories का होता है. पहला, one question of the law fact public importance. The Supreme Court and discretion may give the refuse to the give advice. Third, second, dispute the personal treaty agreement, conveyance and engagement, senders and any other engagement excluded in from the original jurisdiction of the court. The Supreme Court bounded to the give the advice of given to the Supreme Court advisory in the nature and not binding on over the precedent, can't be the use as a means of the revised judgment of the Supreme Court. The supervisory jurisdiction of the High Court. The Article 227, the High Court power to superintendence over all the courts and the tribunals except the military courts and the military tribunals. Judicial jurisdiction of the High Court. High Court has the power to call for return, make general rules and the prescribe the forms, regulating the proceedings, prescribe the format for the books and entires and amount fees and payable to the sheriff clears and the office for the clear petitions extend to the every courts in the trace and the terrestrial jurisdiction, even the High Court not to be the court of appeal. The administrative judicial superintendence revisional jurisdiction में क्या होता है, can be so moto on the petition of the party, power of the superintendence not ultimately power of the High Court over the subordinate court, extraordinary power of the High Court to be used for the very limited case, control over the subordinate courts and High Court. The governor consult with the High Court's matter appointment and the posting the promotion district judges and matter appointment of the appeal to the judicial services other than the district judges. High Court appeal deal with the posting and promotion, grant for the leave and transfer the discipline of the members, judicial services of the state, and the High Court the power to the withdrawal in case Article 228 pending subordinate court substantial question of the law interpretation of the constitution, either the dispose the cases in its own the or determine the question of law, send to the case back in the subordinate court. The judgment of the High Court binding all the subordinate court in their terrestrial jurisdiction. Court of the Record, the Supreme Court. Article 129. The Supreme Court, Court of the Record, judgment, orders, and proceedings recorded by the permanently can be the seated the precedents of the future cases in the front of the other courts also. And can't be the questions and the legal reforms. The power to the punish for the attempts. Article sorry, 1991 Supreme Court judgment power to the Supreme Court punish for the contempt of the Supreme Court, High Court, subordinate court, and tribunal. Contempt of the Courts Act 1971 bill introduced recommendation for the H N the Sanyal Committee. Contempt of the court, civil or criminal. Civil contempt, the willful disobey any judgment, order, or writs of the court, willful breach and the undertaking the given to the court. Criminal contempt में lowering authority of the court, interfering the judicial process, obstruction of administration justice, the fair criticism and the grievance reporting, the not a contempt of the court, punishment of the contempt of the court, imprisonment or the fine or the both. The courts, the initiative proceedings for the contempt within the 1 year of the contempt of court act 1971 not applicable. Nayana Panchayat Arse and the other village court. The Court of Record High Court. Article 215 High Court, the court of the record, and the judgment, order, and the proceeding record of the permanently can be the seated the procedures and future cases in the front of the other court also can't be the question in the any subordinate court. The legal enforces power to the punish for the contempt of the court act 1971. High court power to the punish for the contempt of the itself and other subordinate court. The High Court power to review and ratify on judgment and to a specific power of the review mentioned in the Constitution. A judicial review of the Supreme Court power to the Supreme Court examine the constitutionality laws and both central and state government if the ultra virus against the constitution will be declared null and void. The Article 13 and the Article 32. The Supreme Court tests the constitutionality laws. Judicial review. High Court. The power of the High Court examine the constitutionality laws central and state government if the ultra virus and declare null and void. Article 13 and Article 226 power of the judicial review High Court के पास. Article 226A inserted by the 42nd Constitutional Amendment Act 1976. High Court not be the test the constitutionality central law. The repealed by the 42nd Constitutional Amendment Act 1977. Judicial review Supreme Court and the High Court. Third grounds to be declared a law null and void against the fundamental rights, against the constitutional provision, law made by the legislature beyond the capacity of the authority. The review jurisdiction Supreme Court. Article 137 Supreme Court power to review its own judgment pre-review petition to be the fulfilled within the 30 days from the original judgment to be the same judge or the bench delivered of the judgment. The grounds for the review petition, law, facts of the new a new evidence and disobey the error or the mistake of the law, any other sufficient reason. Rupa Ashok Hurra versus Ashok Hurra 2002. The curative petition not mentioned in the constitution. Curative petition में If the review of the petition dismissed, curative petition can be the submitted in the court to be reconsidered of the judgment grounds of the curative petition violation of the principle of the natural justice, cure of the cross injustice, prevent the absence of the process of the court, bias of the judge, the other powers and the Supreme Court power of the Supreme Court decided by the dispute declared by the decided the president and the vice president, original justice and the final jurisdiction, the inquiry, behavior and conduct or the defense of the president of India, chairman and the member UPSC, SPSC, JPSC. If the found the guilty of the misbehavior, recommended the removal of the president and the advice of the given to the Supreme Court binding. Article 139 as the inserted by the 42nd Constitutional Amendment Act 1976 power of the Supreme Court transferred the certain cases. The Supreme Court transferred the cases from the High Court to the another. The complete delivery of the justice transfer of the case power of the Supreme Court in the case of the similar question of the law pending before the Supreme Court and multiple court. The Supreme Court on the its own the unapplicable attorney general or application of the any party withdraw all the cases itself decided by the substantial question of the law. Article 141 judgment of declared by the Supreme Court, the binding on the all courts and the territory of India. Article 144, the All Civil Judicial Authority Act add and the Supreme Court. Article 142, the enforcement of the order and decrees of the Supreme Court, the enforcement throughout the territory of India. Power of the Supreme Court to pass any order, the complete justice under unrestricted jurisdiction of the Supreme Court order should not be go against the statutory provision. The Supreme Court power to make order scrutinize attendance of the person, procedure for the document, investment and the punishment and for contempt. The Supreme Court power to the superintendence all the courts and the tribunal of the court. Article 138, the union list matter. Parliament power to in a large jurisdiction of the Supreme Court power to other matters can be the in a large bias agreement between the center and state. Article 140, ancillary power of the Supreme Court, meaning additional or the superintendent's power. Supreme Court, the power of the Parliament, give the ancillary power Supreme Court for the complete delivery of the justice. Ancillary power can't be the reduce the impact. Original empowers the Supreme Court and the Article 145 rules of the Supreme Court. Supreme Court the power to make on rules, approval of the president, hearing the case, maintaining the record and delivery the judgment and person to practicing before the court and the procedure for the appeal and review the procedure for enforcement fundamental rights, course of the proceedings, rules of the bail, stay on the proceedings, rules of the frivolous appeal, rules for the procedure for inquiry, rules for the Supreme Court, fixed number of the judges and the create the benches of the hear the access. Power of the single judges and the division of the benches. Constitution bench to hear the case involve the substantial question and interpretation of the constitution. The minimum 5 judges are required under the Article 143 to give the advice to the president. Minimum 5 the judgment of the open court. The advice given to the under Article 143 a opinion court and the all judgment delivered by the majority wording. Judgment can be the given to the descending to the judgment. Article 147 reference to the interpretation of the constitution. Interpretation of the constitution plus interpretation of the government of India Act 1935 plus India Independent Act 1947. The Article 131A inserted by the 42nd Constitutional Amendment Act 1976, the exclusive jurisdiction, the Supreme Court test the constitutionality of the central laws and the repealed by the 42nd Constitutional Amendment Act 1977. India versus USA. Indian Supreme Court original jurisdiction federal dispute, the appellate jurisdiction civil criminal and the constitutional case, a special leave petition advisory jurisdiction, limited judicial review jurisdiction case can be enlarged by the parliament power to the superintendence of state court. यूएस सुपरिटेंडेंस कोर्ट में क्या होता है, ओरिजिनल जुरिडिक्शन होता है, फेडरल डिस्प्यूट होता है, एम्बेसडर्स एंड द नेवियल फोर्स मैरिटाइम activities, appellate jurisdiction only the constitutional case, no special leave petition, no advisory jurisdiction, wide judicial review powers of the power to jurisdiction only in constitution, no such power to superintendence in USA Supreme Court में. The subordinate court. The subordinate court, the state judiciary high court is the subordinate court function under the subordinate court. The part 6, article 233, article 237, subordinate court, appointment of the district judges. Article 233, appointment of posting and the promotion of the district judges are done by the governor and consultative high courts. Eligibility, district judges not to be the services central and state government, advocate 7 years. Should be the recommended by the high court. Subordinate judiciary, article 234, the appointment of the person other than the district judges recruited by the one of the governor, consultation state public service commission. And the High Court, the Article 235, the High Court control over the subordinate court and the district court. The High Court power to exercise superintendence, positioning, promotion, and leaves and the people belonging to the judicial services interfere the district judges controlling by the High Court and the interpretation. And the Article 236 interpretation, district judge includes the judge of the city civil court and the additional district judge and the chief justice of the small court. And the chief presidency magistrate, additional chief judge, chief presidency magistrate, session judge, additional session judge, and assistant session judge. Judicial service to be fulfill the post district judge and the fulfill judicial post and the judicial force district judges. The other provisions of ordinate court, article 237, governor to be the public notification provision, public applicable to the state judicial services, also applicable to the other case magistrate, the with the some modification. The structure and the jurisdiction of the subordinate court, structure, jurisdiction, and the nomenclature determined by the state. The varies across the state, high court, district and the session judge. दो टाइप का होता है, सिविल साइड होता है सबऑर्डिनेट जजेस कोर्ट एंड द मुफस्सिल कोर्ट. क्रिमिनल साइड में होता है चीफ जुडिशियल मजिस्ट्रेट एंड द जुडिशियल मजिस्ट्रेट. डिस्ट्रिक्ट जज में हाईएस्ट लॉ ऑफिस ऑफ द डिस्ट्रिक्ट सिविल एंड क्रिमिनल केस, ओरिजिनल अपीलेट जुरिडिक्शन डिस्ट्रिक्ट जज, टू रोल्स ऑफ द सेम पर्सन, सिविल केस एंड द डिस्ट्रिक्ट जजेस. क्रिमिनल केस में सेशन जज होता है, जिस डिस्ट्रिक्ट में जुडिशियल पावर होता है, एडमिनिस्ट्रेटिव पावर होता है, सुपरविजनरी पावर होता है. ऑल स्मॉलर कोर्ट में विद इन देयर द डिस्ट्रिक्ट अपील अगेंस्ट द डिसीजन एंड द डिस्ट्रिक्ट जजेस. हाई कोर्ट में क्या होता है, High Court. The session judges power to the lift the imprisonment, death punishment are given to the session judges to be the validated by the High Court Chief Justice of the Magistrate in case of the criminal side. The imprisonment up to the 7 years subordinate judge civil judges senior most advisory or the class civil matter unlimited imprisonment civil suits and the term and the mandatory value. The Mufasil court the civil judges case 2 and the civil judges senior advisory civil cases में limited economic value judicial magistrate criminal cases में up to the 3 years इम्प्रिजनमेंट अदर एरियाज सबऑर्डिनेट कोर्ट में क्या होता है सम मेट्रोपॉलिटन सिटी सिविल कोर्ट होती है सिटी सिविल को मेट्रोपॉलिटन मैजिस्ट्रेट क्रिमिनल साइड में सम स्टेट प्रेसिडेंट टाउन दिल्ली बॉम्बे एंड कलकत्ता मद्रास स्मॉल कॉजेस कोर्ट में सिविल केस स्मॉल वैल्यू. In the summary of the manners High Court's part of the revision and the some state में पंचायत कोर्ट आता है petty civil and the criminal case article 233A inserted by the 20th Constitutional Amendment Act 1963 validated appointment of the district judge and the judgment of the past by them if they did not follow the process article 233 article 235 the retrospectively. The tribunals. Tribunals क्या होते हैं ओरिजिनल कॉन्स्टिट्यूशन नो प्रोविजन रिलेटेड टू ट्रिब्यूनल 42nd Constitutional Amendment Act 1976 the part 14A and the article 323A article 323B ट्रिब्यूनल से रिलेटेड आर्टिकल 323A द एडमिनिस्ट्रेटिव ट्रिब्यूनल आर्टिकल 323B ट्रिब्यूनल्स एंड अदर मैटर्स द एडमिनिस्ट्रेटिव ट्रिब्यूनल आर्टिकल 323A द पार्लियामेंट्री बाय द लॉ. Establishment administrator tribunal and the jurisdiction of the dispute and complaints related to the recruitment and the condition of the service union state and the local authority other administrative creation of the administrative tribunal transfer of the case civil courts and the high courts and no tribunal the SPD justice civil servant administrative tribunal act 1985 using the power article 323A central administrative tribunal state administrative tribunal central administrative tribunal में central administrative tribunal set up in 1985 the principal bench Delhi. Additional bench other state में 19th bench including principal bench 9 circuit sittings and the central administrative tribunal original jurisdiction dispute related to the recruitment and the service matter service covered all the Indian Service Central Service and the Civil Post Center civil employees of the defense employees not the covered by the Central Administrative Tribunal personnel and the Defense Forces Office of the Servants and servants of the Supreme Court secretaries staff of the Parliament Central Administrative Tribunal multi-members body one chairman and the 69 member earlier vice president law no vice person all the members draw from the judicial and administrative system minimum age limit chairman and the members to 50 years of the age maximum age limit chairman 70 years and member 67 years 10 years 4 years का होता है appointment chairman and the members made by the central government recommendation होता है search for the come selection panel headed by the chief justice of India or judges of the Supreme Court and nominated by the chief justice of India. and the Central Administrative Tribunal not bounded a new old code of the criminal procedure principle of the natural justice appeals application of the process fee rupees 50 होता है applicant appeal himself through the lawyers the L Chandran Kumar versus Union of India 1997 the Supreme Court ruled by the appeal against the order and Central Administrative Tribunal division bench and concerned the High Court the candidate approached the Supreme Court directly. The State Administrative Tribunal Act 1985. The State Administrative Tribunal established by the central government on the request of the state government. State Administrative Tribunal original jurisdiction dispute related to the recruitment and services chairman and the members appointment by the central government on the recommendation of the search selection panel headed by the Chief Justice and the concerned the High Court. A joint administrative tribunal administered by the Tribunal Act 1985 provision joint administrative tribunal two or the more state on the request of the concerned state administrative tribunal the Supreme Court special leave petition and over the decision of the tribunals for the other matters article 323b. The Parliament and state legislative power to create tribunal adjudication of dispute related taxation, foreign exchange, import, export, judiciary, land, industry and land reform, sealing and the urban property, election of the Parliament, state legislature, food staffs, rent and the Tenancy Act added by the 75th Constitutional Amendment Act 1993. The decision of the tribunal under the Article 323b can be the challenge only in the High Court, not directly to the Supreme Court. A special leave petition of the Supreme Court applicable Tribunal Act Article 323b. L. Chandran Kumar was Union of India 1997. The jurisdiction of the Supreme Court and the High Court and Supreme Court can't be the excluded. And the differences between the tribunals. Uh, Article 323A Tribunal only for the public services can be created only for the Parliament by law. One tribunal for the center, one for a state, no hierarchy. Article 323B Tribunal for the matter other than the public services can be created by the Parliament or a state legislature by the law. Hierarchy of the tribunal may be created. Lok Adalat and other court legal services authorities article 29 free legal aid and a poor and a weaker section justice for the all the legal service authority act 1987 enforced the 19th November 1995 the purpose to free and the competent legal services equal opportunity weaker section and the uniformly across India NALSA, National Legal Service Authority, monitored by the implementation of legal aid and programs laid down by the policy and principle, provide the legal services. Supreme Court सुप्रीम कोर्ट लीगल सर्विस कमेटी स्टेट लेवल पे स्टेट लीगल सर्विस अथॉरिटी हाई कोर्ट लीगल सर्विस कमेटी डिस्ट्रिक्ट लेवल पे डिस्ट्रिक्ट लेवल सर्विस अथॉरिटी तालुका लेवल पे तालुका लेवल सर्विस कमेटी पर्पस टू द इम्प्लीमेंट पॉलिसी ऑफ द नालसा प्रोवाइड फ्री लीगल एड एंड रेस्पेक्टिवली लेवल में मेन फंक्शन में फ्री लीगल सर्विस एंड रिस्पेक्टिवली स्टेट the payment of the court fee and the process of the fee any other charges related to the court proceedings and legal service of the lawyers obtaining the supply certificate coins and the legal order and proceeding preparation of the appeals and the translation in the legal document etc. The origins of the Lok Adalat settlement of the dispute legal awareness camp, the free legal services eligibility for the free legal services women and children, SC and ST community, industries workers, the victims of the disaster and the floods, a disabled person, the person in the custody of the law enforcement enforcement and the authority power. The person of the those who annual income not exceeded rupees 1 lakh. In the case of the Supreme Court, annual income limited the 5 lakhs. The victims of the human trafficking bearer. Lok Adalat, meaning the Court of the Appeal, the Statutory Court Legal Service Authority Act 1987, to the give the and give the backing judgment of the court. The forum the it resolve dispute using the negotiation, conciliation, and the human approach pending before the court. A court at the pre-litigation stage is still the court for the method of the alternative dispute resolution expedition of the expensive dispute resolution to provide free and the speedy justice, add and the reduce the burden of the court. Lok Adalat, no court fees, and if the court's fees are paid to be the refund by the case of the settlement in the Lok Adalat. Specific features में flexibility and speed. Lok Adalat no winner and the loser. The first Lok Adalat 1980 to the Gujarat, the Supreme Court, High Court, SL, DSL, and TSL. Origin of the Lok Adalat decided by frequency, area, jurisdiction, interval, and judicial officers was serving out the entire the number of decided by the originating authority. Composition of the Lok Adalat chairman, judicial office. A lawyer, a special worker jurisdiction of the Lok Adalat. Any case pending in before the court, any matter under the jurisdiction of the Supreme Court not binding before the court. The complements officer complaint can be withdrawal of the charges against the person and explain the theft and the chieftain for the simple hurt, etc. No compoundable or no compoundable offense, and the withdrawal of the charge of allowed can be the settled only with the approval of the court. Example rape of the offense, crimes against the women and children. Lok Adalat jurisdiction only for the compoundable offense, no jurisdiction, no compoundable offense. In the case of the referred to the Lok Adalat only when the parties agree to refers to the case of Lok Adalat on the parties to application of the court refer to the case of the Alada court certificate matter should be the taken up to the Lok Adalat. In the case of the pre-legit litigation case refer to the Lok Adalat on the parties application of the organizing authority. Lok Adalat, some power the Civil Code of the Civil Procedure 1908 of the Code of the Criminal Procedure 1973. The matters and the summoning the witnesses, the examination of witnesses, discovery of the document, procedure of the documents, public recommends the documents from the any court. Lok Adalat, and the power and specific on procedure. The all proceedings demand for the judicial proceedings under the Indian Penal Code award of the Lok Adalat. Thank you very